tonight. Spare a thought for Melbourne man Colin Ross, who just recently was pardoned 86 years after he was executed for murder. It's a dramatic example of the terrible consequences of wrongful convictions, and yet in Australia an innocent person still has no rights once their case is being dealt with through the legal system. In South Australia alone there are at least a dozen such cases, but today Parliament was offered the chance to vote on a proven solution. Graham Archer has more.
These are the lucky ones, if you can call spending years in jail when innocent lucky.
I can't even comprehend what it would be like to be doing time for another person's crime, knowing in your heart that you're innocent, and the effect that that would then have on your family and friends as well. It would just be devastating.
A bit like being buried alive.
Absolutely. Absolutely like being buried alive. And I guess no way even to claw your way out of it.
Really is devastating. I mean, financially, they're ruined. They're ostracised by society, and it has a devastating effect on their personal relationships.
Others are not quite so lucky. Perth's John Button had to wait 44 years to be cleared of murder, and Victoria's Colin Ross was exonerated 86 years after he was executed.
The pardon for the convicted murderer came after author Kevin Morgan tested hair samples used in evidence.
There can be no more tragic proof that our justice system can get it wrong.
Nothing human is infallible. It has its weaknesses. Of course, it has its strengths.
It's a point the barrister, the journo and the judge all agree on.
We should certainly aim to eliminate the errors, the wrongful convictions, the miscarriages of justice.
Michael Kirby spent 13 years on the bench of the High Court of Australia and is very familiar with the weaknesses and the strengths of our justice system.
The biggest strength is that our country has uncorrupted judges who are very serious about their duties, take criminal cases and criminal appeals very seriously, but obviously mistakes happen, and then the question is, what do we do when that occurs?
Currently in Australia, there's very little you can do. Once you've been convicted and exhausted the appeal processes, there's almost no way back, even if startling new evidence is unearthed. The system effectively washes its hands of you, and not even the High Court has the power to intervene.
The High Court won't receive new evidence, however compelling it may be, and that is, I think, a weakness in our appeal system in Australia, that we can't, in the final court, receive fresh evidence where, for example, it is it's compelling and it shows that the person is actually innocent.
The system is set up so that it's supposed to work properly, and there's nothing really for the people who fall between the cracks and the system doesn't work properly for them.
Perth journalist Colleen Egan wrote a book documenting the years it took her, family members, a couple of politicians and a dedicated group of lawyers to free Andrew Mallard, who'd served 12 years in jail for a murder he didn't commit.
I think it's a lot easier for the government, the politicians, the legal fraternity, the police force, the courts, for everybody, if they don't concede that an innocent person is in jail. It's a lot easier for them if that isn't real.
On the Stafford case, 3 lawyers, 3 scientists, a journalist, an academic and a private investigator took about 4 years to finally have the conviction overturned, and all of those people worked for no money. So it's very difficult under the current system to have a wrongful conviction overturned.
Barrister Joe Crowley, based at Bond Uni, was one of that team which managed to have Queenslander Graham Stafford acquitted of murder after having spent over a decade behind bars.
I'd just like to thank everyone that supported me throughout all this nightmare.
The burden of overturning these wrongful convictions really is shouldered by innocence projects like the one we have at Bond University that worked on the Stafford case. In a developed economy with a sophisticated legal system like Australia, I think that we probably could come up with a better way to proceed.
Miscarriages of justice are common to all states, But in South Australia, since the acquittal of Edward Splatt 25 years ago, not one case has seen a judicial review.
The media tends to report the high-profile miscarriage of justice cases, so that I don't think that members of the public really understand how many wrongful convictions there are at all levels of the criminal process.
The only hope of having a case reviewed is to petition the Governor. This ends up with the Attorney-General, who can send it back to the court or simply reject it.
There is always a risk in a country which unfortunately engages every 3 years or so in a law and order campaign in elections. There's always a risk that that can intrude into the completely dispassionate consideration of a case.
That's been the dilemma for Henry Keogh. The former Attorney-General Michael Atkinson has engaged in a personal and very public crusade attacking any prospect of a review.
Today Tonight claims that important pieces of evidence were withheld from court. This is wrong. I deny it. I deny it. I deny it.
And yet he was the one person with the final word on the fate of Keogh's petition.
Decisions of the Attorney-General are decisions of the Executive, and as such aren't reviewable by a court and aren't able to be appealed against.
And regardless of the strength of the evidence, that's the end of it. In Britain, they were forced to deal with this problem after the intensely political prosecutions of people like Paddy Joe Hill of the Birmingham Six and Jerry Conlon of the Guildford Four, both wrongly convicted of IRA bombings, despite the police's own informant telling them,
"You've got the wrong people." And he sat there and made a detailed statement to them, and he gave them the names of the two people who made the bombs, where they were made, etc. And he gave the names of the three people who came along an hour later, picked them up, primed them and planted them.
Yeah.
And they had all that information within 6 days. But by that time, they had tortured us so much that the last thing they could do was let us go.
The UK adopted its system because of the so-called Irish cases, a series of cases in the 1970s and 80s in which people were convicted of Irish terrorism offences.
They set up a Criminal Cases Review Commission to objectively re-examine convictions which had gone wrong, with the power to send them back to the court.
So that is a sort of fail-safe system. Anything that works in the United Kingdom system of criminal justice would work in Australia. Our system is modelled on the UK system.
Since 1997, about 464 cases have been referred back to the court system.
And how many of those have been overturned?
About 300.
So that's upward of 60%.
That's right. And we would be very arrogant to believe that our court system and judicial system here is above mistakes and above error, and that there aren't people in jail here serving time for crimes that they did not commit.
There are at least a dozen cases in this state which could be classed as potential miscarriages. And so today, Independent MLC and Bressington introduced a bill into Parliament to set up a Commission of Review, or CCRC, based on the UK model right here.
We know that there's a gap in the system. We know that this is lacking. We know that this is long overdue.
And she has very influential support.
And that's what they've adopted in the United Kingdom. And I think we really need to consider such a system in Australia.
I don't think that there's any reason it wouldn't be as successful in Australia if we implemented it.
I think if we've got a system that does put people in jail and does convict people, we should also have a system that reviews cases when they get them wrong.
So here's an opportunity for South Australia to remake its image as a leader in dispensing of genuine justice rather than an embarrassment.
In a federation, sometimes you experiment. One state may take the step and then it may be seen as a good step for the whole country. And I expect that that may be what will happen in Australia.